Thank you all for coming tonight. I know it is late on a Monday, so I appreciate you all being here. Today, we're going to focus on this webinar where we're going to go over the proposed revisions to Ordinance 2026-62. I will also sometimes refer to it as AO 2026-62 and the impact that it will have on civilian oversight. While this ordinance is being presented as a step towards accountability, tonight we will discuss the limitations of the ordinance. So first, we're going to start off with why this conversation matters. For at least for myself, at least the last 6 years since 2020, I've been working with families of officer-involved shootings, MMIP cases, and suspicious death cases. And one of the things that they have been asking for these last 6+ years is that we have actual accountability when it comes to these cases. They've called for transparency, accountability, independent oversight, fair investigations, and having community trust in APD. For many years, families impacted by missing and murdered Indigenous people, or MMIP, and officer-involved shooting cases have spoken about the lack of transparency and accountability within existing systems. Many families hoped civilian oversight would create independent review and investigative powers, not simply another advisory body, which is what is being proposed in this ordinance and its revisions. When we look at what families experience after an officer-involved shooting, a lot of them are dealing with the same challenges over and over. There's often limited communication, delays in getting access to reports and footage, and overall, there's not a lot of transparency while the investigation is happening. Families are left with a lot of uncertainty about what's actually being done and what the outcome is going to be. And many also feel shut out of any real oversight process. What most families are asking for is pretty straightforward. They want timely updates, an independent review of what happened to their loved one, clear explanations they can actually understand, and real accountability when it becomes clear that an officer-involved shooting case is not what it appeared to be. When we talk about oversight, it also connects to a much bigger set of concerns in the community, including missing and murdered Indigenous people, suspicious deaths, and cases where there's been some level of law enforcement misconduct. In all of these situations, families and community members are often left asking the same kinds of questions. How are these concerns actually being reviewed? Who is providing independent oversight or oversight of any kind? And what kind of transparency is really in place for families and victims trying to get answers? The big question, why are law enforcement officers so rarely charged criminally after an officer-involved shooting? So I get this question a lot when I have OIS, I'll say OIS often for officer-involved shooting. When I have OIS families that I'm working with, is what is going to happen with the officers that shot their loved one? Is there going to be any criminal charges pressed against them if it appears that the officers were wrong in the case? And sadly, I usually have to say that that most likely won't happen. And I'm going to give a couple of reasons why. And sorry, it's going to be a little bit wordy, but I think it is really important for the community to know why we don't see officers charged with OIS cases. And that is because there are protections for law enforcement. And one of the main protections that they have comes from Supreme Court rulings that give officers a lot of leeway in situations where they would come on scene, and there's somebody either with a gun or a weapon, or even if they don't have anything at all, but it's kind of like a fast developing situation. They're given a lot of leeway. And that comes from one of the cases is Graham versus Connor. And it's where courts are required to judge an officer's use of force based on what a reasonable officer would do in the moment, not with hindsight. Also in Tennessee versus Gardner, the court held that deadly force is allowed when an officer has probable cause to believe someone possesses a serious threat of death or major injury to themselves or others. Together, these standards make it legally difficult to second guess officer involved shootings if the threat can be considered reasonable at the time. So that's kind of at the federal level where you have those rulings in place that make it difficult for officers to be charged. They get a lot of leeway because of that. In addition, Alaska has officer use of force protections in Alaska Statute 1181-370. This covers an officer when they're illegally justified in using force while making an arrest or stopping an escape. It essentially provides an affirmative defense in criminal cases, meaning officers can't be convicted if their actions fall within this legal justification. Under this law, deadly force is allowed when an officer reasonably believes a suspect poses an imminent threat of death or serious physical injury, or that immediate action is necessary to prevent harm to themselves or others. So with these two, one statute and also the Supreme Court case rulings, when you combine these two together, it really makes it hard to charge an officer after an officer involved shooting case, because what they usually will say, and you'll hear often when there is press conferences for APD, that there was a fear of death or a fear of injury to the officer, and then, or maybe a fear of injury or death to others around them, and that's why they shot. And so once that's been said, they're pretty much covered. And very rarely can you really make a case where a person doesn't fear of threat or injury, because it's kind of a very loose definition. If we start to think of that, like what might make me afraid and fear for my life might be different for you. And that's where that leeway comes in. So if you have further questions on these cases and on this statute, feel free to email me. I'll have my email at the end, and I can connect you with a legal resource that can explain it further. I'm just getting this information from somebody that I know as an attorney, who looked over my slides and gave me some insight into how to put this into layman terms, but they're willing to give further explanation if you would like. So please feel free to send me an email if you want further explanation from an attorney on that. We're going to go over the current complaint processes for APD and the concerns that we have with those. So as of now, without this ordinance in effect, we have three main complaint processes that families or victims can submit to if they feel that something was done wrongly during either arrest, which would be a misconduct, or from the death of an officer involved shooting case, or even when we have MMIP families or suspicious death families that feel that the investigation was not done properly, or something was done, improperly by an officer during that case. They can also use these complaint processes. So the first one we have is specifically for Anchorage, and that is making a complaint to the Anchorage Police Department, it goes to their Internal Affairs Department. The complaints are investigated internally by APD. Families often feel investigation lacks independence because it is an internal investigation. And then outcomes are generally not transparent because they are not available to the public or to the families themselves. It is considered, private information most of the time because it's how internal affairs is kind of like what we would consider, I guess, in our regular workplace, like an HR kind of department in terms of how they hold information. So that's why you won't usually see much being said about officers after an officer involved shooting case. Even if a complaint is made to internal affairs, their information is usually pretty protected that way. You can also make a complaint to the Anchorage Ombudsman. They review complaints involving any municipal government or department. So one of the complaints you can make is to make a complaint against the Anchorage Police Department itself. After you make a complaint, they can investigate that situation, but really the most that they can do is make a recommendation to the Anchorage Police Department. They don't have any direct disciplinary authority over APD. You can also make a complaint to the Alaska Police Standards Council. What they do, and this is one that you can make a complaint for Anchorage Police Department as well as troopers or any other police department here in the state of Alaska. So they're more of our larger complaint process space. If you were going to make that complaint throughout the state anywhere, you don't have to just stick to the first two unless you're Anchorage based. But they review officer certification and misconduct concerns. The process for these complaints can be a little bit difficult to navigate, and the result of the complaint is often limited and rarely visible to victims or families that are making that complaint. You generally are not going to know the outcome of that complaint, or you might get a little bit of information, but it will be very basic and not very thorough in explaining whatever the outcome was. So when I'm working with families, whether it's officer-involved shooting cases, MMIP cases, suspicious death cases, I still go through these 3 complaint processes with the family. I usually will walk them through the complaint process. I'll help them with the forms. I'll help them get them submitted because they are quite overwhelming, especially if you are making a complaint after your loved one has been shot and killed. You're in the middle of grief, so that's a lot. If your loved one is recently missing or murdered and you're an Indigenous person for an MMIP case, it can be very overwhelming to have to go through these processes on your own. So at Empowerment Advocate Alaska, we actually walk families and victims through these processes so that they don't have to do that by themselves. Overall, though, these complaint systems don't often lead to real accountability because they're split across multiple agencies with limited power. APD Internal Affairs investigates itself. That's basically what the outcome is APD will investigate itself is the easiest way to put it. And then, of course, that raises concerns about transparency and really if it's independent, because that'd be like you doing a investigation into your own misconduct. It generally is not going to be very trustworthy. The Anchorage Ombudsman can review cases, but can't discipline officers. So that's one of the big issues is, they can just make those recommendations. It doesn't mean that there is going to be any sort of disciplinary action or any sort of policy change necessarily. It's really just a recommendation. The Alaska Police Standards Council is going to mainly handle the certification issues with officers if there is found to be something, wrong with the officer's conduct. But then that can also be hard to track and it is rarely visible to families. So because there's no single body that has both independence and enforcement authority, outcomes for these processes are often limited and unclear. We'll briefly go over what the original AO 2026-62 proposed. There has been changes, and that'll be in the next slide, but I think it's good to just kind of do a quick overview of what the original ordinance was. It would have created a commission that reviewed public safety concerns, made recommendations, advised leadership, such as municipal leadership, is I guess is how I should have wrote that, like the mayor, encouraged community discussion, but it would not have been able to independently investigate complaints, subpoena records or reports, discipline officers, or force policy changes. So in its original form, the proposed commission was advisory only. That means it could have made suggestions, but it had no authority to independently investigate complaints or require action from the Anchorage Police Department or municipal leadership. So if you were here maybe roughly about 2 weeks ago for the other webinar I did, this is one of the main concerns we had with the proposed original ordinance. But now we'll go on to the next slide where there's actually quite a bit of concerns with the substitution that they've added in. So what are the revisions and substitute version of AO 2026-62? And I'm sorry, this is going to be a little long, but I wanted to be pretty thorough with people because if you were able to give testimony during the last assembly hearing on this ordinance, you would be able to do so again on this upcoming assembly meeting, which is tomorrow. But you will have to stick to speaking on the substitute version, so the changes that they made. So I wanted to be pretty thorough with you guys on this, so that way you would still be able to have an opportunity to give testimony if you had already done so previously. So the first change that they made that was clear was the change in name. So it went from the Anchorage Public Safety Commission to the Anchorage Public Safety Partnership Commission. This is more than just a cosmetic change. The original version followed a more traditional advisory oversight model where public safety agencies provide information and input but don't have voting power. The substitute changes the structure by giving these agencies a direct role in how the commission operates and makes decisions. The name change is significant because it reflects a change in who has a seat at the table. The other change we see is that the public safety agencies gain direct voting power. Under the original ordinance, the Anchorage Police Department, Anchorage Fire Department, Department of Law, and Office of Emergency Management and Department of Health could provide information, but they did not have voting power. Now, under this substitute, they do have voting power. The substitute version shifts the approach by giving agencies a direct role in the commission's governance, making them active participants in decision-making rather than just advisors. It creates a situation in which the agencies have more say in oversight process than they did before in the original version, which means these agencies would participate directly in commission decisions. So I kind of give a little example here. The substitute version has 9 community commissioners, which would be like your community members, and then 5 public safety agency seats. And now they would all have the ability to vote versus the original, the 5 public safety seats had no voting power. So now they do, if this ordinance passes as it's written with the substitution. The Department of Law receives a formal seat. So the Department of Law and prosecutors, one thing to note is like they evaluate incidences involving officer-involved shootings, use of force incidents, criminal investigations. The substitute places one of these entities directly on the commission as a voting member. There is no way to assure that this seat will remain impartial when voting. So it is a little, no, not a little, it's very concerning when we have someone at the seat, at the table who has a seat that has voting power that directly looks at, and I'll give an example here, officer involved shooting cases. If there's an officer involved shooting complaint and someone on this commission has a directive vote over how far they look into this complaint, what they do with this complaint, that, the concern of transparency and accountability just really lights up there. Originally, having them as a non-voting seat was a concern, but now having them as a voting seat should really spark some major just red lights for us. APD becomes the permanent administrative home. So the original version shared support responsibilities among APD, the Anchorage Fire Department, and the Emergency Management Department on a rotating 6-month basis. The substitute removes that rotation and permanently assigns support responsibilities to the police department. The substitute centralizes scheduling, coordination, and staff support within APD, and that raises concerns about the commission's independence and APD's influence within the oversight process. So just another, red light, red flag right there when we're talking about transparency and accountability, is how is that going to look when we are placing these so much power in these seats amongst agencies that actually are involved in some of the cases that the complaints will be about. So review authority is further restricted. The original version allowed the commission to look at broader patterns and system-wide issues. The substitute version limits the commission to reviewing cases only after they are finished, and that reduces its ability to address concerns while issues are still happening. The new language closes a possible interpretation that the commission could monitor developing incidents or receive information before investigations conclude. The substitute explicitly limits review until everything is completed. And this is a big issue for families seeking answers after an officer-involved shooting. This means that the commission cannot become involved during the active stages of a case. So it really depends on each case how long it'll be open or active with an APD. And if we are asking families to wait until everything has closed out, that may be months, several months. And that is, really unfair to families to ask them to wait before their complaint can even be looked at, really, until everything is closed and completed. And that's something that, when we're talking about just ensuring that people are treated fairly and people are treated with dignity as surviving family members of officer-involved shootings, they are surviving family members. Their loved one has been killed. They should be treated with the same dignity as any other case of homicide. In fact, if somebody is killed by a law enforcement officer, it is classified as a homicide. So, technically they are still surviving family members of homicide, whether certain agencies want to acknowledge that or not. At Empowerment, we acknowledge OIS family members as surviving family members. But what they're basically asking here through this revision in the ordinance is that these families will just have to wait for however long the case comes to a conclusion, and that's just really hurtful and unfair to those families. So the new language limits access to active cases. The original version only prevented the commission from interfering with investigations. The substitute goes further by also blocking the commission from engaging with or requesting information about active investigations. So this matters because the substitute doesn't just say the commission can't interfere. It also stops it from even seeking information about active investigations, which is a much stronger restriction. So very similar to the bullet point above. It's really like limiting the access of information to this commission. So disciplinary oversight is also further limited. Originally, the commission couldn't make disciplinary decisions or recommendations, but with the substitute version, it actually expands that restriction by also preventing the commission from participating or influencing any disciplinary decisions at all, even if it's indirectly. So they just basically hammered even further down on that ability to give any sort of disciplinary action towards officers. And then agencies receive guaranteed leadership representation. So that's the public safety agencies. In the original version, the commission elected its own chair. In the substitute, it locks in a structure where a community member is chair, but a public safety agency representative is always vice chair, means that the public safety agencies are always going to be guaranteed a leadership role on this commission, whereas in the previous one, that was not always guaranteed. So then we go into oversight without power. Can accountability exist without enforcement? Our key concerns are there's no subpoena authority, there's no independent investigations, no disciplinary authority, no guaranteed policy changes, no direct control over complaint outcomes on really the original ordinance, and even more strongly on this substitute version. Oversight bodies are often most effective when they have the authority to independently review evidence, compel cooperation, and then publicly report findings. Without those powers, we need to be questioning whether meaningful oversight can actually happen. Advisory versus investigative oversight. What's the difference? So with advisory, which is what they're proposing here, with really restricted advisory, I guess I should say, they can give recommendations, they have limited authority, they rely on departments to cooperate with them. So they rely on, let's say, for instance, APD to cooperate with them. And then they cannot enforce any outcomes. They can't enforce policy changes. They can't enforce disciplinary action. With investigative oversight, they conduct independent investigation. They review evidence directly. They have stronger transparency tools, and they create greater accountability. So under investigative civilian oversight, accountability and transparency would come from an independent body, like those described by the National Association for Civilian Oversight of Law Enforcement, also for short, NACOL. NACOL is one of the leading organizations in the nation that helps communities form civilian oversight bodies. At one point, I believe the task force, prior to this ordinance becoming an ordinance, they had a task force. They had one meeting with NACOL, and I believe it was just one. NACOL themselves have volunteered their time about 4 times total, I believe, to give webinars here for the Anchorage community. That was not done through the municipality or any of the nonprofits. That was actually done through the Party for Socialism and Liberation Anchorage, had made connections with them in 2020, and they were very kind enough, NACOL was very kind enough to give webinars through PSL Anchorage to kind of inform the community of what civilian oversight could look like. So NACOL has had somewhat of a role in our community here. It just seems that the commission that's being developed is not taking the lead of NACOL's, the standards of practice that they have when it comes to real accountability and transparency within a civilian oversight body. Instead of police investigating themselves, an outside office would run its own investigations. If we had an investigative civilian oversight body, they would review evidence directly and look at things like body camera footage and witness statements independently. It would also be more open with the public when it comes to clear reporting and updates on cases. Independent reviews and more transparency and outcomes would be easier for the community to have trust if we had an investigative civilian oversight body. The community and families that are making these complaints could have more trust in the independence and transparency of that body if it was investigative rather than advisory. And also, as I said, with all the substitutions added, that makes it even harder for these families. So as the Assembly prepares to vote, community members should carefully examine what this ordinance with its substitution actually does, and then also what does it not do. Public oversight only really works when communities clearly understand the powers and limitations involved. The proposed substitute ordinance will not create real transparency or independent oversight, as it shifts oversight towards a model where public safety agencies actually end up having more control. And I have a list of some questions that we should be asking, and that can also be used if you are going to give testimony. So one of them we have here is, why is the Department of Law given a permanent voting seat when it is also involved in evaluating officer-involved shooting incidences? What safeguards exist to prevent APD's role as the administrative home from influencing what information the Commission receives or prioritizes? Why is the Commission restricted from requesting or receiving information about active investigations, even when no interference is involved? How can the Commission provide meaningful oversight if it can only review cases after they are fully closed? If the Commission cannot participate in or influence discipline in any way, what mechanisms ensure accountability is actually achieved? That's one of my biggest ones. And then how does guaranteeing a public safety agency as vice chair affect the balance of power between community members and those public safety agencies? So public testimony and community action. How can we speak up? So one of the things that we can do is attend the assembly hearing, which is tomorrow. It starts at 5 p.m. at the Lusac Library. You can give in-person public testimony. You can also submit public testimony via email. You can contact your assembly members via email. You can share if you are a family member, an MMIP family member, an officer-involved shooting family member who's had a suspicious death case, or a victim of officer misconduct. You can share those experiences with the assembly when you're giving your testimony, and explain, why having proper civilian oversight is important. And then, advocating for stronger oversight powers. If we are going to accept the current ordinance with its with its changes, if that is voted in, ultimately, what will happen, and this is in my opinion, of course, but just my many years of doing this work and working with families, is that the ordinance won't work out. Families and victims will go to this commission with complaints, and they will have the same outcome that they have with the 3 other complaint processes we currently have, most likely. And then you're kind of left at square one again. And so it really is a benefit to all of us as a community if we are asking and advocating for stronger oversight powers, because we never know when a situation can affect us. We always would want to, hope that it doesn't, but you also just don't know. And we should be thinking as a community, what's best for all of us living here, what's going to keep us all safe, and what's also going to ensure accountability when that time comes, if there's something that's happening within law enforcement that shouldn't be happening. It's really in all of our best interests to participate. So the upcoming assembly hearing, I just have some information here on the day, which is tomorrow. It starts at 5 p.m. It's at the Lusac Library. I also call it Midtown Library. I don't know if that's right, but it's at 3600 Denali Street. When you walk into the library, when you walk through the front doors, it's kind of right to the left side. You'll see the big glass assembly member chamber doors. You'll walk through there, and there's lots of seating for anybody who hasn't gone to an assembly meeting before. I always want to pre-warn people that assembly meetings can be quite long. It starts at 5 p.m. We may not get to testimony on this ordinance for some time, or it might be one of the first things that comes up as well. You just kind of never know. So I like to give that warning out to people that do plan to attend the assembly hearing, is kind of be prepared to either be there until very, very late in the evening, or you may be out of there by 7, p.m. I don't know, but kind of prepare yourself for that one way or the other. And then if you have any questions,